afternoon, everyone. I can still see that there are some people standing by the door, so if you like, you can make your way and find a seat. We still have some seats available in the front. It's a few minutes after the official start, so let's begin this session. So good afternoon, everyone. My name is Professor Kubo Mačák. I teach international law at the University of Exeter in the United Kingdom. And so I'm going to say just a few words of welcome. That's the honor that I have. But other than that, my role is quite easy because then I'm going to pass over to Talita, who's going to introduce the topic of the panel and also our wonderful panelists who are here with us. But I thought that I would start by sharing a personal story with you during this short opening remarks, because it's something that brings me back to Tallinn, actually to CyCon almost 10 years ago, where I came to this conference with a paper in which I asked, perhaps very ambitiously for a young academic that I then was, is international cyber law in crisis? That was the topic of the paper, so a very small one. And then, you know, the crisis back then, for those of us who remember those days, were these discussions whether states are not relinquishing their role when it comes to developing and clarifying international law in cyberspace. And so the debates that were happening back then were, because there was a relative state silence in this area, that there were other initiatives, non-state-driven initiatives that were filling this relative power vacuum at the time. And so in my paper back then, I proposed that, you know, one of the roles how states could reverse that trend or address that trend was to become more forthcoming about expressing their opinio juris, about expressing their views on international law in cyberspace. I was for sure not the only academic making that claim. There were a number who were arguing that that would be the right way forward. And if we do indeed fast forward to 2024, we see that by now about 30 states, depending what methodology you use, about 30 states have issued such comprehensive public-facing statements on interpretation of international law in cyberspace. Also, one regional organization, the African Union, has followed suit with the Common African Position earlier this year. So we definitely no longer have a vacuum in this sense. But what we do have now, I would suggest to you, is a bit of an uneven playing field. So the statements that we have are of uneven level of rigor and detail, and also many of them come from the same parts of the world. And that's mostly global north. So this is why today, in response to this trend, we are launching a new project. And so that's why I have the honor to addressing you first, because today's event basically serves two functions. One is to talk about some of the substantive issues that Talita will introduce soon, and one is to launch our new project, which is called the Handbook on Developing a National Position on International Law in Cyberspace, a Practical Guide for States. And so our consortium is formed very much of some of the people representing some of the institutions that you see up here on the stage. So in addition to my institution, the University of Exeter, we have joined forces with, of course, today's host, the host of this conference, the CCDCOE, and then also the Ministry of Foreign Affairs of Estonia and the Ministry of Foreign Affairs of Japan. So that's our project consortium. We are funded in part by the UK government's research funding from the Economic and Social Research Council in the UK. And basically the aim of the project will be to produce this handbook following a series of meetings with states, both those who have already issued their national position papers and then those states that are in the process of considering doing so, of considering a national position of this sort. And so our aim will basically be to produce a handbook which will provide this practical guidance on substantive and procedural questions that relate to these national positions. And so it's a delight to share this news with you, attendees of CyCon, and hopefully 1 year from now, when we meet again, we will be able to share the fruits of our labor. That's the aim, to produce the handbook in time for next CyCon, where we aim to launch it and then discuss it further. And so I'm going to stay here and be very happy to take questions about that. And I also invite our speakers who have in various roles contributed to the process of preparation and to the consortium for the project to comment further in their remarks. But with that, I'm going to pass over to Talita, who will introduce the topic of the panel and our panelists. So over to you, Talita.
Thank you so much, Kubo. Welcome everyone to CyCon, the first day, and welcome to our panel on national positions on international and cyberspace, challenges, opportunities, and best practices. As Kubo said, the purpose of this session is twofold. We're both going to delve into this topic of national positions, but we're also going to tease out some of the questions that the handbook will address over the course of the next year during the research. And as Kubo said, national positions have now been issued by a significant number of states, about 30. Maybe a little bit more because as we will discuss, the format of these positions vary a lot. Some are more informal than others. One regional organization has also done the same. It has issued its common position on international and cyberspace. And as we know, national positions have become an important vehicle for the clarification of how international law applies in cyberspace. They deal with fundamental and controversial topics from sovereignty and non-intervention to countermeasures to due diligence, dispute settlement. And in doing so, national positions are a welcome development in terms of greater transparency, confidence building among states. It's also very helpful for us researchers in making sense of, how to interpret international and cyberspace. And one important development as well is that these positions have an impact beyond cyberspace. What we have been looking at is the development of international law generally in this particular context. So what is said in cyberspace doesn't really just stay in cyberspace, right? So there are impacts beyond cyber. However, most of these positions, they do come from global north countries, and they're based on a global north model. And they also vary, as I said already, they vary significantly, both in terms of the format. Some are more deep, some are very long, 20 pages. Others are very short, 1-2 pages. And the substance is also very different in terms of the topics they address, but also in terms of areas of agreement and disagreement. And, there are also questions about what is the legal status of these positions. Are they opinions? Are they state practice? Are they just policy statements? And so there are a lot of questions up in the air. And so it is against this background that we will try to address some of these very topical questions and other questions surrounding the issue of national positions, and use the feedback that you provide us today in our project. That's what we're going to try and do today. So to discuss this topic, we have a stellar panel of speakers with us today. So starting from that end, we've got Dr. Ágnes Kasper, who is the head of the law branch here at the NATO CCDCOE, Cooperative Cyber Defense Center of Excellence. She's also a senior lecturer of law and technology in the Department of Law of Tallinn University of Technology. She has also served at embassies, human rights organizations, and acted in an advisory capacity in consultations with governments on various cybersecurity issues. And she was also an external expert for the European Commission, and legal advisor for a startup accelerator supporting cybersecurity startups. Her current research focuses on regulatory aspects of cybersecurity, cyber defense, and cyber diplomacy. So we also have with us today Tomohiro Mikanagi, who is legal advisor and director general for International Affairs Bureau to the Ministry of Foreign Affairs in Japan. He is a diplomat. He served in London, New York, and Beijing, and he's also a published author on various issues of international law, not just in cyberspace. Right next to Tomohiro, we have Mr. please forgive me if I mispronounce your name. I don't speak German. Schabedoth?
Perfect.
Great. He's a desk officer and the coordination staff for cyber foreign and security policy at the Federal Foreign Office of Germany. And before joining the Federal Foreign Office, he worked at the German Federal Ministry of Economic Affairs and Climate Action in the field of international investor-state dispute settlement. And last but not least, right next to me, we have Kerli Veski, who is Director General of the Legal Department at the Ministry of Foreign Affairs of Estonia since 2015. And she covers various areas of public international law, as well as Estonian law and EU law. And international and cyberspace and accountability for crimes have been priorities over the last years for her and remain so in the nearest future. So thank you, everyone, for taking the time to be with us today. So the way in which we're going to run this panel is we're going to try and engage in a very organic and conversation or discussion among all panelists, guided by questions, and then we're going to leave some time for a Q&A with the audience at the end. Okay? So if I may start with one question for Ágnes. So Ágnes, you are one of the co-investigators of this handbook project. And so, and we've been thinking together collectively about this question of, the importance of national positions. But could you tell us a little bit about, what in your view is the legal and the practical importance of issue those positions?
Thank you very much, Talita. Thank you very much, Kubo. It's a pleasure and honor to be in this exceptional panel and launching this important project. So special thanks goes to Karina, helping us with in all sorts of practical manners. So I'm very happy to be here and really have high hopes that this project will produce very practical resource and guidance in basically how to develop a national position. So your question, Talita, is basically that I translated it that way, that okay, why would a nation want to develop and come up with a national position? So what's their motivation? So today it's a matter of consensus already that malicious cyber activities may result in potentially devastating security and economic and social and humanitarian consequences. Take, for example, the 2022 ransomware campaign against Costa Rica. That's just a fantastic example of these potential consequences. And there are various tools to respond to these challenges. There are policy strategy. There can be policy and strategy measures or tools, legal tools, technology tools. So these national positions basically have utility both as a policy and strategy as well as a legal tool, and different states attach different importance to these. So in the national positions already, some of the states are mentioning these points, like what's the motivation? Why would they come up with a national position? And very often they point out that, look, these promote transparency and common understandings, for example. They contribute to further clarifying and developing international law. Some states also mention that these national positions contribute to reducing the risk of misunderstanding and escalation between states. So some of the national positions communicate as their main motivation expressly, but not all of them. In some of the national positions, this is missing. However, in other places, for example, in national cybersecurity strategies or equivalent documents, they may point that, okay, particular states, the desire to contribute to the development of international law and influencing the interpretation and development of international law. Some of the positions mention that a national position enhances preparedness to face the consequences of malicious cyber operations, and it's an enabler to calibrate one's own responses. And since you have to do that when you develop a national position, it also has an effect that a state internally needs to determine, consolidate, and clarify its own views. So what goes into those national positions. So coming up with a comprehensive and consistent position is a non-trivial exercise, and this national position can arguably be used as a tool also to deter and respond to malicious actors. So use it as a strategic tool. So you can see that national positions can serve as a policy strategy tool, but of course, from the legal perspective, they play also a specific role in the normative architecture that governs and also constrains conduct of states in cyberspace. So it's now universally accepted that existing international law applies in the cyber context, right? International law lays down these minimum standards of responsible state behavior, this binding on state, so violations of which may result in international responsibility, etc. But in this area, we do not have dedicated treaties for state conduct, cyberspace. So the exact scope and boundaries of this international legal framework and the specific rules are subject to interpretation and disagreement. So a small group of states, for example, argue that essentially there is a legal vacuum until a dedicated international treaty is adopted. In my personal view, this approach can be seen as an attempt to avoid accountability for violations of international law until there is now a new treaty adopted, a new cyber treaty, so to say. So this is a minority view held by a few states. Nevertheless, it's important to recognize that these states are key players also in the international arena, and they advocate that the only way to guarantee legal certainty is through the adoption of binding treaty, and this position is seemingly gathering some traction in the, especially among, so to say, global majority of global South countries. So national positions, on the other hand, with some exceptions, elaborate on how the existing international rules of international law applicable to cyber operations are identified and applied. Some of the states are very express in this way. Sweden, for example, says that, well, new treaty is not needed, and we have enough and good enough rules. But, for example, Norway and Poland, they go a slightly different way and express that these positions are regarded as opinio juris, so a constituent element of customary international law besides the general widespread practice. So opinio juris as such may come from public statements, official publications, governmental legal opinions. So it's not difficult to see that how these national positions may fit into that category. So, on the other hand, this needs to be matched with practice, and we among ourselves already had a discussion that, okay, what do we consider as practice, how visible that practice might be, and this is one of the challenging areas. So national positions elaborate on a broad spectrum of international laws, not only on regimes governed by customary international law, but also on international treaties. So in this context, a national position can be regarded as, at the least, as a means of interpretation under the Vienna Convention on the Law of the Treaties. And they may become generally accepted interpretation as soon as there is sufficient number of states would agree on that. So, on the other hand, if you look at global treaties like some Geneva Conventions, this might be quite a challenge as well due to their large membership. So, in conclusion, national positions can serve various purposes, and we will be very interested to see actually that what would be the motivation, or what would be the main concerns of states, not from the global north, but also from other parts of the world. So these national positions also have a specific place and role in the international legal architecture. So if state is, that's the aim, that okay, and we want to contribute to the development of international law and uphold the rule of law, then of course these national positions are also a tool, and this is a motivation for adopting these national positions. So the is aim to clarify the exact contours of rules that apply, but also I might say here that they do so in a way that does not create an accountability gap. Not, so to say, preaching, but also for this purpose, so practicing responsible state behavior. So.
Thank you, Ágnes. It's very interesting that you mentioned that many states use their national views or positions to deny the applicability of international law, right? They're using it for a counterintuitive way. And there are also many states that deny particular rules of international law, the applicability of particular rules of international and cyberspace in their positions, and that varies across the globe. We've got states from the global north and global south doing that. So that's also very interesting. You've mentioned that national positions are an important way to develop and interpret international law. And I referred earlier to the interesting phenomenon that we are seeing of national positions being used to develop international law more generally, or as a testing ground for the development and interpretation of international law more generally. Tomo, you have written extensively on various topics of international law generally, but also in cyberspace. So you're a generalist international lawyer. So what is, in your view, the impact of these positions beyond cyberspace and international law more generally?
Okay, I have prepared a slide here. First, I'd like to thank Kubo and Talita for organizing this wonderful workshop. This is my second participation in CyCon, but the first one was online during the COVID time. So this is my first in-person participation in CyCon, and very much looking forward to that. Ágnes pointed out very important fact that some states are still resisting the application of existing international law to cyberspace. But we have worked very hard among the UNGG members and other OEWG discussion in UN, and I think there is a consensus. Existing international law applies to the cyber activities. We thought it was a big achievement, but it was only the beginning. Then the big question was how the existing international law applies. And then we had a big challenge. I think that big challenge is mainly from the difficulty of applying existing norms relating to territorial sovereignty. Because rapid, the large-scale cross-border data flow is a hallmark of cyberspace. And that is unprecedented from the viewpoint of international lawyers. And we pretend to know the rules that are applicable to this new phenomena, but how that rule applies, that is a big question for all the practitioners. And at the same time, we have been discussing the already published national position of 30 national governments and African Union. But even among the so-called global north, there's a deep disagreement about very basic norms relating to sovereignty. But at the same time, we are realizing that we need some rule that can apply to the cyber activities to maintain minimum international peace and security. So I think national positions are very important to apply the existing rules of international law, but that involves their review of the positions they have been taking on the very basic rules relating to territorial sovereignty. And I think we need to strike some balance in the end to have some minimum rules relating to the data flow and territorial sovereignty. So I think national positions are important vehicle for us to discuss what should be the balance we are going to strike. As I mentioned, there's a big difference among the even among the global North governments about how rules of sovereignty applies to cyber activities. And this is a kind of rough, categorization of all the existing positions, starting from any cross-border cyber operations into the foreign territory without authorization of the territorial state amount to violation of territorial sovereignty. This is a kind of extreme fundamentalist approach to the sovereignty and cyber activity. And B is cross-border cyber operations causing any effect in the foreign territory amount to the violation of territorial sovereignty. Some criteria threshold is emerging here. But C, cross-border cyber operations causing effect above de minimis level. For example, some physical damage or loss of functionality in a foreign territory could amount to violation of territorial sovereignty. So the threshold is going up little by little. The D, cross-border cyber operation causing serious physical damage or loss of functionality to another state's critical infrastructure may amount to violation of territorial sovereignty. And E is a kind of extreme position, but cross-border cyber operations amounting intervention, only those amounting intervention constitute violation of sovereignty. This is a rough categorization, but there's a big a spectrum of ideas, even in applying this basic norm of territorial sovereignty. Because before, when we had to talk about violation of territorial sovereignty, we usually talked about the policeman visiting another state and doing some investigation. That was considered to be the violation of sovereignty if there's no consent from the territorial government. But now you don't have to send a real person to another state to investigate into the server existing in another state. And sometimes we don't even know where that server is, if their data is stored in the cloud data storage. So these conceptual categorization, but we are still at the very early stage in making progress on this very basic issue. And I thought this is kind of a very pessimistic description of the current state of affairs, but it is possible, even through the negotiation or discussion among the states, to find some common ground, like this. This is a kind of minimum common denominator among the diverse positions. The first, the more serious the effect of the cyber operation by one state in another state territory is, the likelier it is to violate the latter state's sovereignty. This is a kind of relative concept, not the absolute concept of threshold. But there's a kind of consensus. The more the effect is, the likelier it is to be a violation of sovereignty. So we can first maybe agree on that kind of very relative concept of threshold. Then cyber operation by one state against another state, critical infrastructure, i.e. infrastructure which is critical to the state's basic function causing physical damage or loss of functionality. So this is a kind of a most serious kind of cyber attack to cause the state, could be violation of latter state sovereignty. So this is a kind of suggestion of agreeing on some minimum thing and then expand it to the wider consensus. But doing that kind of discussion would require these suggested attitude of the state. I think states publishing new national positions should look at other states' positions and hopefully try to find common ground rather than finding disagreement. In that way, you can find a greater agreement among states. Secondly, even those states who have published national positions, including Japan, should have some flexibility in discussing these issues. If you say, this is our position, eternal position, which cannot be changed through time, that would, I think, close the door towards the consensus among states. And I think thirdly, the technology and the way of utilization is changing, developing. So it is very natural for states to adjust their position accordingly. So we need to review our already published national positions. If there is a new tendency, new need, necessity, we need to change our position to some extent so that we can find some minimum rules applicable to the cyber activities. So I started with very pessimistic note about the current state of discussion. But I think the increasing number of national positions published by the government is encouraging phenomenon, especially African Union's publication of their position is really good new step toward consensus. So I hope that would stimulate more states to come up with their own national positions, but hopefully keeping these 3 points in their mind. Thank you.
Thank you so much, Tomo. So yeah, absolutely. So here we see the importance of thinking about process, right? Thinking about keeping the position under review continuously to cover new technological developments, the importance of dialogue with other states, but also internally, the importance of finding common ground, perhaps by focusing on use cases or case studies like critical infrastructure. So all of these practical questions are also very important. So now I'm going to turn to you, John, because as we know, Germany has issued a very elaborate national position on international and cyberspace. So in your experience from a German perspective, could you tell us a little bit about the practicalities involved in developing that position in terms of how you organize that, who you consult, how you select the topics? Could you share us a little bit more about the German perspective?
Sure, yeah. Thanks for the opportunity and the invitation for us to discuss this topic. Germany has released its public position on the application of international law in cyberspace in 2021. And this was a long process, so it took us quite a while. But we made some experiences, some lessons learned from that time. And yeah, we're happy to share those. And we're in constant consultations with other states, so those experiences that I want to talk about today are mostly mirrored by other states as well. So, because I think the states, and I think there are some in the room as well, who might have different, like the same experiences, they might be the same in most of the states. The first question, and I think Ágnes really told us about this before, the state should ask themselves, why do they want to publish a national position paper? For us, all the reasons you mentioned were perfectly the right reasons, and we wanted to send the signal that international law is binding and applicable in the cyberspace, because and just to send this message and to publish this paper. Our national position paper was issued only in English, which is something German bureaucracy normally doesn't produce. So that tells you something about the messaging we wanted to do. We wanted to reach out to the world and to tell them what our opinion is on this issue. When we looked at what the content of the paper, the scope of the paper would be, there are like 2 things where you can say you want to produce like a really long paper, but then you might lose flexibility, as we've heard. You might lose also capacity. You cannot just write an academic paper with the capacities you have in a ministry. So those are some things, and then you don't want it to be too superficial. So you have to find a line between those things. And for Germany, it was just that we focus on mostly on the norms of the UN Charter, and then some issues that are important to us: attribution, generally state responsibility, international humanitarian law. So those are things that we thought that would be very important and that we need to introduce into this paper. Both in regard to the scope, but also to like the substantive things that we talk about, we looked at other papers. Of course, there's a lot of academic work. There's a lot of other national positions already in line, and of states where we would normally say, okay, we can look what they do. This is not an academic work where you can have to cite footnotes or anything. If you like something, you can just use it. Yeah, like like in a thing. So, and there's the GGE at that time. So they produced a lot of papers that we took into our process to evaluate both on the scope and also on the content. But I think the biggest lesson we learned was to involve all the national stakeholders that have something to say about this topic, because both in the way like of ministries, so for us it was mostly my ministry, the MFA, and the Ministry of Defense, who in Germany are the competent on this topic, responsible. But in other states, this might be some other institutions like cyber security agencies or anything like that. And it's important to keep them in the process from the beginning and to have them in line, to have long emails with a lot of recipients from those institutions. But it's also important when you discuss at what kind of level you want to have you want to publish the paper, like if it would be on the minister level. Some states, I think, even went for like the prime minister's speech or something. So you should keep them in loop as well for those kind of things. So you need a big group of people to discuss the paper, but I think what we learned is that the actual work of drafting the paper, that is something that should be put into the hands of a smaller group, like a really dedicated group of lawyers from the ministries working on this thing, and also to have a coherence on the language and stuff. So this is the way we did it. We had a small group, and they drafted different drafts of the paper, and then they were consulted with the other participants, and in this way we had several rounds of this, and that's how we came to the final version of our paper. For that, it's also important, of course, to have a clear timetable and precise deadlines for even consulting with the higher levels in the ministries, and also to talk with other states about their opinion, to involve academia. So yeah, that helped us. We had a session for the GGE at the time in mind, for which we wanted to publish the paper, so that helped us in like getting our deadlines fixed. Maybe one additional point, wording and language, this might not come to a surprise, but they matter. So we try to address the paper in a way that would be understandable, and I hope we succeeded with that, to a broader audience, so not just like legal nerds, but like really a bigger audience of people. So yeah, that was one of the things that we had in mind. And also, as we heard about this before, that customary law, the way it's built, you really have to have a strong position in the wording. So if you want to say something is your opinion, yours, you have to use certain vocabularies for that you would use, and there are some like keywords, some buzzwords that you normally states use when they want to say that something is legally binding, or if they only think that something should be legally binding. So those kind of wordings, even though for some people they might not be noticeable, it's very important to keep them in mind. Maybe the last thing we learned is to have a clear publication strategy. not the last thing we learned, but like the last point that I want to make today. There's a lot of things to learn from this process. So we published our paper online through the official channels of the ministries, but also used it for like international forums like the GGE or the OEWG, so where we just introduced our paper. And then we also had an online briefing to introduce the position to other states, to tell them, okay, this is what we do, this is the reasons behind our paper. So I think it's good to kind of think a bit further on, to like not just publish it and then have it in the air and then like nothing follows up from that. And yeah, those are the kind of the key experience that we found from this process. And we're looking forward to this your initiative with the handbook. And from the German side, we're very eager to support this project. And there's some talks going on, but we would very much like to support it and do it in maybe part of one of our cyber trainings with the African Union, cyber roundtables. And yeah, we're happy to support the project. And thank you very much.
Thank you so much, John. These are all very invaluable lessons on the practical side that will surely be helpful for us in drafting this and the handbook and developing the research, but also for other states that are considering issuing their national positions. And as you rightly noted, the selection of issues goes to what a certain country considers important, right? There is policy behind all of these decisions, right? It's not an easy decision. And Kerli, if I may turn to you now on this, Estonia has already issued a couple of positions or statements, if I am correct, too. Very different ones, but nonetheless, two equally important positions. So in your experience from an Estonian perspective, what are the key legal and policy dilemmas facing states when issuing those positions?
Thank you. And first of all, thank you very much for having me here at the panel and, of course, launching the handbook. We are very much looking forward to having that handbook, and we would have very much appreciated to have had that in 2018 when we started our elaboration and positions. It was a totally different situation then. And very much has been said already, and probably I'm gonna mirror some of them. But let me start with that. When we started, yes, in 2018, and we ended up in 2019 with our president's speech here at CyCon, then it was a bit less than a year's process. So it took quite a while. And the dilemma started from the very beginning. And what were they? And I'm guessing that they are still at the table for quite many states today. So first of all, like was mentioned, what topics to include. And maybe today it would be just easy to follow what the others have done, because I mean, this is a very fruitful source of information that we have, how other states have already outlined their positions, how detailed, how general. Very good source. Also, of course, cannot mention just to say that Tallinn Manual has been a huge support for us, at least back then. And of course, we are hoping that that will continue that process as well, including national positions and also academics. I might say that academics have been a real push, not only in cyber, also outside of cyber, that you have really dragged us forward. Like you said yourself, that you need to do something, your states. It's not only academics who produce different papers. So that was in the background that we really needed to understand what we will produce and how can we achieve it. Being a small state, it is actually a very difficult task. I'm sure it's difficult for everyone, but especially for small states, because you have so scarce resources. And it's not only that you need to engage all the agencies, and all the other agencies beside the Ministry of Foreign Affairs will look at you that, but we don't have enough resources to have this theoretical exercise. We have our everyday work to do. It's kind of, write it yourself if you want to have it. So that was one of the dilemmas, I may put it in that way, not only challenges, but dilemmas, how to engage all those agencies, but at the same time, not to use up their resources too much. And like you said, also your experience was that you need a team who will probably do it in a smaller group, but then engage with all the others. We'd had the same exercise, actually. But we needed to engage with all the others, and the main reason is that it can't be just an exercise for international law lawyers. Mm. That's the main challenge, and I'm sure it's up till today for everyone that it can't be first a theoretical exercise and it can't be just for international law lawyers. So we really needed to understand if it's really applicable, that we really, how it's the expression, we walk our talk, that we really are sticking to those positions also after we've published them, and not only in cyber, but in general, in international law, because we say that international law applies in cyber, so it should be vice versa as well, that everything that we say in cyber, it should be applicable also outside of cyber. So you mentioned that we've had different papers. Yes, first was in 2019. The second for the GG in 2021. It was more of a policy paper, not so much maybe legal. At least that was our aim. And we are once again considering to renew our positions. And for those particular reasons, what we mentioned already. First, our position was very general in 2019. I might say that it still is. I explain a bit later why. And the second is that international law is evolving, especially the last, sadly to say, but the last 3 years. I mean, this has really been a challenge to international law. And everything what we said 5 years ago, we would rephrase quite many things today already. And as you know, in 2019, our president said out loud that we are supporting collective countermeasures. Back then, it was discussion, oh, this is very novel. It's maybe only, lex specialis for cyber. But today, we see that we have quite a lot of practice outside of cyber already. So somehow, other domains are following what at least then was said in cyber. So why have we remained quite general? One of the reasons is exactly that we would want to stick to what we've said, so that it wouldn't be just on paper and then we say that, yes, but this is one thing, but in practice we do what we want to do. We want to stand behind our words. And probably the biggest challenge there is that we expect from states that they lay out their whole understanding of how international law applies in one paper. We never do that outside of cyber. We never do that. And now states are expected to have it on one paper, either in 2 pages or 20, doesn't matter. It's still very, very difficult because you don't usually open to so many positions of how you actually apply international law, because there are so many different situations, there are so many different dilemmas or contextual aspects that you need to take into account. So how do you actually provide a detailed paper when you don't know what tomorrow brings? So I guess one way to look at it is that you renew your statements time after time. The other is, yes, you be less detailed, but then maybe hold on a bit longer. Then what was mentioned already, forming opinion juris. We certainly agree with that those statements are part of forming opinion juris. But then once again, there's the dilemma, where do we want to move that opinion juris and how much you can actually say about it, and once again, follow it in the end. So I would also put it as one of the dilemmas, not only how detailed you would be in your statements, but how much you actually need to take into account when you do that. And then maybe my final point at the moment would be capacity building, especially for a small state, but I'm sure it's for everyone. The big challenge is that first, you might not have that many international law lawyers who would be available to do that job and who would be really ready to take all the context in and actually try to formulate something, general based on what you know and what's the experience that you've had. But then there's also not that much state practice, and not only in terms that it's not public, but there are quite many issues where you actually maybe have only few incidents that you can consider, and especially if they haven't happened to you, they somehow are more distant to understand and how actually that would have influence on your state and what would I do if I were in that situation. So that I would also put as part of the capacity building that we really need to share our views, and we've done that in the EU among like-minded states, and of course, not mentioning open-ended working group, but there are different forums, and that means also that different level of detail can be shared depending on who you are talking to and how big the group is. But I'm sure that also those discussions, different workshops, summer schools, not only for young lawyers and young experts, but also the ones who worked on international law and maybe in cyber specifically for years, they still need this, that we need to talk to each other. Maybe that what we've done a couple of years ago now, different workshops based on scenarios, because then you also see that, okay, we might be on the same position with particular state, but then when it boils down to a specific scenario, to a specific situation, then the devil is in the details, like always. And then you somehow find that, no, we are not at all on the same position. So that's why I find it really important that we discuss it. Also, CyCon, the best place to be. And also to develop this handbook, because I feel that it would be really, really useful for those also who've already taken the position, but who would want to elaborate on it.
Develop it.
Thank you.
Thank you so much, Kerli. And you're absolutely right that the practice is not enough and also sometimes unclear, right? So for example, on countermeasures, we don't know whether states are responding to an internationally wrongful act or just an incident, right? And that complicates our task of understanding what's going on and assessing, what is the status of different international rules and principles. So that's very important. I absolutely agree with you. We need more dialogue, For better or worse, we need to get people together in the same room to discuss these issues. And the stakes are much, much higher now for states because these positions are getting more and more elaborate, pages and more pages. And that has implications of, on what is expected from states. So going back full circle on Kubo's project on silence, okay, so if a state remains silent, then what does that mean in that new context of so many national positions? So these are all open questions for us to discuss. I'm going to open up the floor now for the Q&A. If you have questions, comments, please feel free to jump in. Yes, Chris.
Firstly, good luck with the new project. I have, I'm afraid, a nerdy legal question. There's been quite a lot of discussion about what these state positions do in terms of their relationship with the development of customary international law, potentially being very important sources of opinion jurists. What about state practice? Is there a consensus among the panel, among the states that you're speaking to, as to whether these state positions can also count as state practice? Be interested in your thoughts about that, as well as opinion.
So may I put this question to the panelists back to you, Ágnes, Tomo, John, and Kerli? State practice as well. Tomo?
Yeah, it's a very difficult question because we as a practitioners, because we don't know what law is applicable to our activities, it is difficult for us to publicize what we are doing.
Yeah.
Because that might be regarded as unlawful activity. So what is happening now, the opinion juris part or discussion part is moving faster than actual state practice. And maybe there are some state practice already existing, but states are not willing to publicize that without knowing what is the law applied to their activities. It's a kind of dilemma. So we need to move kind of simultaneously. We have to develop a discussion on the rules. At the same time, if there is a kind of a growing consensus among rules, we can also publicize what we are doing. And this, in tandem, hand in hand kind of development is very difficult for the practitioners to actually do. There's also pressure from domestic audience, what your government are doing. Yeah. Then to what extent can we publicize what we are doing in the cyberspace? Then there's another pressure from outside. Other state might criticize what you're doing. So these are kind of dynamics, but the hesitation for the states to publicize national position or their state practice is partly caused by the, ambiguity of the law. And that dilemma cannot be broken without, engaging in discussion among states to find some consensus.
Thank you. Kubo?
Yeah, thank you. I agree with everything that Tomo has said. I would just add a little bit about the methodological aspect of your question, Chris. If I understand it correctly, you're taking us down the line of the elements of customary international law. And so how do these statements issued by states count for the purposes of emergence of new rules of customary international law? I think that's an excellent question. And as we have heard from several colleagues on the panel, sometimes states say what they intend to do, very often they don't. So in some of them we have a state saying, we intend this as a statement of opinio juris. But your question is, can it also simultaneously count as an instance of state practice? And I think, to my mind, this is an excellent but unsettled question, and I can explain why. For the International Law Commission, in their study on looking on the elements of customary international law, they are quite clear that statements, so what states say, is also an instance of states doing something. I mean, right now I'm doing something, I'm talking to all of you, so I am acting in a certain way. However, there is a problem in double counting certain instances of action as both state practice and opinio juris, particularly if those statements are very general in nature. Because customary international law, as a process of emergence of new rules of custom, is inductive and is very focused on specific instances of practice that happens. And so, to my mind, the position papers, like those we also want to support with the project, are quite general in nature, and so they are not very compatible with this inductive nature of customary international law emergence. It's different kinds of statements that the ILC had in mind, like a diplomatic protest, right? So that's a verbal statement that relates to a particular instance. But as I say, this is my view, and it's by all means not settled, and it's also not settled because states are very cautious in saying this is how we qualify this issuance of a position paper. So it's an excellent question. We will probably touch upon it a little bit in the handbook, in the methodological section, but I'm sure there are, PhD students around the room taking notes, and I think there are really interesting projects in looking into that question.
Yeah. Any other thoughts from the panelists, Kerli?
Yeah, only shortly, just to add what's been said, I agree with that. But maybe also to be cautious with state practice, also not only in cyber, but also outside of cyber. What we do by diplomatic means is also actually not known. And if we don't say it publicly, if we don't publicize what we are doing, and I mean, we never issue I don't know, handbooks or books about Estonia state practice on something. It's just something that we don't do. And I'm guessing that that state practice will be something also in the future that can be seen only in retrospective. What has been done, what states have proclaimed, and what the other states then, how they have responded. And only in retrospective we can see if the statements also coincided with state practice, or are they two different things. And also in terms of state practice, especially in cyber, I'm guessing that why also the positions are general, once again to bring that in, is that in different situations we might want to have a different practice depending on the context. Yeah. And that's why, once again, it is really difficult to put it under one umbrella, general umbrella, and all whatever we do somehow fits into that pattern. So there's the biggest challenge, of course, and we would want to see that all the positions are actually mirroring the actual way of life, but there is a big challenge for that.
Yeah, and on that we have to be very careful about inferring opinion areas from practice, right? To go back to Tomo's, Kubo's, and Kerli's point, you know, sometimes states mean different things, and they don't consider themselves to be doing something that we think they might be doing. So we have to be very, very careful about that, because that might have, you know, serious consequences for that state and also for international law more generally. So caution is warranted here.
But at the same time, if I may, it's not a meaningless paper.
Yeah.
That's something that I don't want to emphasize either. We have to take into account both. Yeah. And that brings also down to the state responsibility in a general term, that you preach what you're actually doing, meaning that we have to take into account both. I'm still thinking that also those position statements those statements are really important also for development.
So that's where I think is this interesting tension between development and interpretation of international law. And so to my mind, actually, when states say what we are doing here is an expression of opinio juris, there is a little bit of a tension in when they say that, and they also say existing international law is sufficient. Because if you say our expression here is an expression of opinio juris, then if coupled with corresponding state practice, actually a new rule of custom emerges. So there is a bit of a tension in saying existing international law is sufficient, and yet we are expressing our opinio juris. So that's when we progressively develop international law. So rather, perhaps a more effective way then is to say what we are doing is we're interpreting existing rules of international law. And so for custom, it's a little bit more complicated, and there are discussions to what extent custom can be interpreted. But a lot of the rules that we talk about are rules of treaties. And so when it comes to treaties, we do have an established methodological route, and that's subsequent practice that establishes the agreement of parties to international treaties about their interpretation. It's a mouthful. It's a part of treaty interpretation rules in the Vienna Convention on the Law of Treaties, Article 31(3)b for the nerds in the room. Yeah, and so the question there is whether the amount of positions that we have so far can be sufficient to establish the agreement of the parties, because a lot of these treaties are multilateral universal treaties, so even 30 papers is not enough. And so we then have to interpret it as a subsidiary means of interpretation under Article 32. But still, the roots are there, and so I think it's probably better to view the position papers as means of interpretation rather than except with certain exceptions, as means of progressive development.
And even for customary law rules, we have many that have a written expression, right, that are expressed in judgments or documents that have been prepared by the International Law Commission. So they have a textual expression. So we could perhaps think about using the same methods to interpret treaties for customary international law, which is yet another theoretical methodological question that I won't go
Thank you, Chris.
Okay, more questions? Yes, please.
Hi. Do you think that the documents that states publish on their interpretation of application of international law to cyberspace should include satellites or assets in outer space? Should it be mentioned in the document? Why or why not?
Interesting. Outer space. Any thoughts on that? There is a panel, by the way, on this, on which Chris is advertisement. Is that a priority for Estonia, Germany, Japan?
In our case, we have separate discussion on space law and cyber international law. Maybe we have to think about connection between these two things. But so far, we have been different, discussions or different space and cyber.
Kerli?
Yes, I agree. They have been different discussions, different forums. But at the same time, that is a really good question in terms of if we say that international law applies. Same way, not dependent on domain, then once again, we should follow that understanding also when we are interpreting or developing anything also in outer space and law, how it applies in outer space. So actually, this is something we are not so just as a caveat, we are not so much into outer space law at the moment in my department, but we are following it. And when we thought about how we would actually interpret international law, and if we would need to have also some kind of, if not a position paper, then at least an understanding, then our first priority then would be that we try to follow the same path as with international law in cyber, and also, for example, the international maritime law, so that we take all of that into account, not dependent on the domain, but that we would still be on similar positions, not dependent on domains.
Yeah. John, does Germany have a view on this?
That's a very good question. So I'm from the cyber division, so the policy side. So it's very hard for me to say what the legal department is doing. But I think it's in general, you can say that those are both topics that are quite like progress. Like there's some progress in those kind of parts of international law. So I think one could look at what is happening in cyber and apply these processes to the space law thing. But So that's a start, I think. But in general, we don't necessarily mix those together, even though it's interesting to look at them from a more holistical way. But
Interesting. Ágnes,
add one thing. When we say existing international law applies to cyber activities, the most basic reason for that is cyber activities are actually using the things placed in the territories of states. So their territorial jurisdiction covers the equipment, machines, PCs, lines used for cyber activities. That is the basic reason for the application of international law. But when you are talking about satellite in the outer space, the outer space is outside the national jurisdiction.
Yeah.
So the existing law is very scarce, actually. No space treaty is there, but it only talks about peaceful utilization of space, no territorialization of moon treaty only talks about territorialization of this moon itself. Well, very basic small rule exists, but not beyond. There's no rules relating to the sovereignty, no rules relating to other rules governing the activities on the Earth. So there is a big challenge if you include components existing in this outer space. We have to think from the start.
Yeah.
Maybe you have to create new rule directly applies to the satellite and things in the outer space. So it's a very good question, but it's a big challenge for international lawyers to actually apply existing rules to that kind of.
And we also need to consider like the outer space component of cyber operations that happen here, right? And that might bring in a whole range, new set of rules, you know, to consider. Ágnes, Kubo, do you have thoughts on this?
Yeah, it's a very interesting question, and it very well demonstrates the overlap of different legal fields and legal regimes. Yeah, but when it comes to outer space, it already has a treaty, in fact. So in that sense, we are not starting from the same same level. There is already something done before. So there are domain-specific or dedicated rules to that. So it's, I think it's, again, different states may attach different importance to this issue. So what is important in my view is to have an informed decision about it, whether the satellites question is in this particular, in this national position, or in a different form. So, and it's a very good point. Thank you very much for raising this, because when we are launching this project, we were focusing on the handbook, and it will have its limitations. But we are already we're considering that, okay, articles, academic articles, basically, is sort of an extension of the handbook. And I thought that one of the articles could be about exactly issues that were raised, that were discussed, but for some reasons, they did not make it to the national positions. So kind of an emerging topic, or what we might see in the future in these positions, but not there yet. Quite.
And there are parallel developments in the AI field, for example, right? Many states are thinking about adopting the same approach to the interpretation and clarification of international and cyberspace to AI. So many states, for example, Switzerland, I believe, have said that, you know, international law applies. Let's use the acquis in cyber to AI. So there are interesting parallels there. Kubo?
Sure, I'll make 3 quick points. So one is just the pragmatic one. To a large degree, as you also hear from my fellow panelists, it's a question of scope. It's a question of file. You know, that sometimes it's just a different file holder, and so these processes, they run separately. So it's a pragmatic issue. The second point is that to some extent, we are in an easier territory. As Ágnes said, we have space treaties. So there's the Outer Space Treaty of 1967, 3 other, or 4 if you count the Moon Agreement as well, which is not so widely ratified. So there exists a corpus of international law treaties, but as Tomo says, they consider peaceful uses of outer space primarily. Still, one key provision is Article 3 of Outer Space Treaty, which is basically a reception clause, right? Which says that international law applies to space activities by the state parties. This is now seen as reflective of customary international law. So that brings in all of international law when it comes to the regulation of space activities. So you could say IHL, etc., should also be included. But maybe people will disagree on that. And that brings me to my third point, that in this area specifically, you know, the controversial questions, we are maybe 10 years behind the debates in cyber. So in the cyber context, the first Tallinn manual, which focused very much on those questions, came out in 2013. And so we do have academic initiatives in the area of this intersection between military space activities and international law, but they are publishing their outputs only recently. So there is the Milamos initiative, which published the first volume last year in 2023, and there is the separate WUMRA manual, both on a very similar topic, military activities in outer space from the perspective of international law. And the WUMRA manual just came out, you know, literally a few weeks back. So bringing it all back to what we have started with, now we have this impetus from these non-state-driven initiatives. There are now these books that say, here's how international law applies in this area. And so I imagine that a lot of this will be taken up by states in various fora, like there is also a space OEWG, in various discussions to say, oh, so now there is this interpretation on the table, we agree or we disagree to some extent. And so we will see more elaboration on that. Whether this will be dedicated to position papers, I don't know, but it's certainly an area to keep watching.
Maybe then, for those interested, do attend the panel tomorrow, or is it Thursday, the day after tomorrow, on this issue. More questions from the panelists, the audience for the panelists. No? Yes.
I take your point on the scope issue, but it seems to me that there are sort of bodies of international law that have some overlap with almost all of the various areas that we're talking about, right? And so it strikes me as a question as to where you draw the lines, where you draw the boundaries, and who the audience is. And so one question I was wondering about was to what extent the project generally or position papers ought to think about more internal domestic applications. So, for example, if we were going to think about freedom of expression as one issue that involves sort of these cyberspace activities, that we could say that there's information coming in and that freedom of expression in part is protecting individuals' ability to access that. And yet we're seeing a variety of states imposing increasingly high walls against external information. Now some states are becoming more and more isolationist. This is not sort of within, I think, a lot of the core areas that we're talking about in this cyberspace domain, and yet it seems to me maybe an increasingly important one. To what extent should states be thinking about articulating particular positions regarding those types of questions, and to what extent perhaps is the handbook project contemplating?
Thank you so much. Does anyone want to have a go on domestic issues that are more relevant? Like dual domestic. Yeah, international human rights.
Yeah,
as well.
I mean, I'm happy to get us started, just to start thinking about this. So I thank you, Scott, for the question. I appreciate it. So I think there is an easy answer for the project. The project is focused on international law, so we will not be looking at how states regulate this domestically. But as Talita says, this is not just a question of domestic law. This is a question of international human rights law. And so a number of these positions, they do at least acknowledge the applicability of international human rights law in the cyber context, and sometimes look with a degree of granularity as to how individual rules of international human rights law apply in this context. So I would have to open up the Cyber Law Toolkit page on IHRL and see, how many of them there are. But I imagine this should be something that we at least mention in the handbook to say, to some degree there is an amount of convergence among states. But I don't know if we will be able to go into this level of detail, specifically on freedom of expression, specifically on freedom of association, and other rights under IHRL that have cyber implications. But it's again a question for us of scope, how broad we want to go, but I think it's a useful one to raise. Yeah. So,
yes, Tomo?
I cannot answer directly to that question, but I have a similar kind of question to myself, actually. I'm covering both, security issue and economic issue. And I am responsible for, preparing the FTA, Free Trade Agreement, and bilateral investment treaties and so on to the Parliament, for the Parliament. There are digital chapter or e-commerce chapter where there are provisions about free flow of data. And they call it digital, not cyber. But actually, this digital chapter is a kind of reverse side or next side of the cyber activities. And when we have e-commerce or digital chapter in EPA, we always have a struggle with this freedom of expression or freedom of I think opinion and so on. Then to what extent our handbook should cover that kind of area? Somehow, people working on these economic treaties think that is their own area. They create rules rather than interpreting or applying existing rules they are making new rules through treaties for the economic activities, business activities. But that rules have some implication for the people who are dealing with security side of the cyber operation. So I think we need to look widely into the different areas of law, which might affect or maybe interfere with our own discussion. And that freedom of expression, human rights issue is one, maybe space is another. And digital chapter in the FTA and investment treaties are also important element, which might be kept in our mind when we discuss issues.
Yeah. Yeah, and one way in which this might come up is if a state decides to focus on case studies, or if we decide to include case studies in the book, naturally all of these different regimes will come up as overlapping or applying simultaneously to the same case study. So that's something for us to think about. But thank you, Kerli.
I was thinking now why, for example, we haven't really included specific human rights topics into our different position papers. And I think that my really short answer would be why not to include all different human rights aspects. At least I'm guessing why we didn't do it, or somehow now expressing it, is that we look at it in a different way. One is to see how general international law applies to cyber. But then what we do in parallel, and it's not something that we don't do, but it's just we do it in parallel, is how different, for example, also human rights conventions apply to cyber, which means that there we have the convention, we have the norms, and then we look at specific norms, how they apply to cyber. Once again, doesn't really matter what domain, but how we apply it there. And that's why we don't really need a general position paper to somehow additionally outline it. Or maybe if we do it, I don't know, in Strasbourg in a certain working group and just applying then one specific convention or one specific norm. And then there, I would say that it's a bit different way of doing it, a different way of looking at it, because there we have the norms already. And why we are struggling with position papers is exactly that we don't have conventions covering all those general international law aspects. And there we need that bigger clarity.
Yeah, and within the UN human rights system, for example, there are a bunch of monitoring bodies and special rapporteurs who are covering these issues from a multilateral perspective and fleshing out the interpretation of various human rights in the digital domain. There might be a consideration as well. Any further thoughts, John, Ágnes, Kubo?
Well, I can just echo that.
Yeah.
Like I think it depends first also on capacity. So it's just a big topic, and then I think you said it perfectly with that. It's not really the. So our paper was just a paper that we put online from the German government. So we might not be the right actor to say how human rights apply, because there's the courts, there's the courts in Strasbourg, there's the parliament who can more clearly define these things, and for that I think we didn't include it, but that's just like my guess right now. We had some. We say, of course, that doesn't mean that we don't think that human rights apply in cyberspace, but it's just not the focus of the paper. Let's say.
Any yes?
Maybe just a few thoughts here. When we're talking about freedom of expression, then also that we can very quickly move to the area of disinformation and information warfare and things like that. And we have been struggling, kind of distinguishing or exactly drawing that line between cyber operations and information operations and things like that. What we see here is that, well, I absolutely agree to Kubo that we have to draw our line and we have our scope, and then that's that many pages, and we have to be selective. On the other hand, we are also recognizing here a sort of a convergence in these areas Yeah, if you think like before 2018, 2017, so a few years back, if you looked at the doctrines and the concepts from Russia, yeah, and the like-minded nations, they were talking in terms of information space, Russian information space, which also includes content. So not just the IP ranges, but also they are talking about content. So when we are talking about content, that brings me to freedom of expression, disinformation, and then there you go. I'm already lost. Okay.
Yeah.
So
and we know how things are with the Cybercrime Convention precisely because of that, right? So it's a bit of a can of worms there. So we are drawing to an end with our panel. It's almost 2. So I just want to hand back to Kubo and to the panelists for any final thoughts before we end. We have lots of open questions, as you've seen. What should be in a position? How should a position be developed? What is the scope of a national position? What does capacity building for a national position entail? What comes next? So I'm going to try to address all these questions in the project, but Kubo, over to you.
Thank you, Talita. Thank you for chairing today, and mainly thanks to all of you for coming and joining us. In such good numbers. It was, or it has been, a very rich discussion, and I'm glad to see this interest, in the topic of national positions. And we are glad to have launched our project together with all of you. My 3 takeaways from the discussion today are the importance of looking for common understandings, the importance of looking for convergences among state positions, and we will definitely try to assist that with the handbook that we'll be working on. Secondly, based on several questions that have been raised, the importance of methodology and of being open about the methodology. Is what is happening a development of customary international law? Is it the interpretation of treaty rules? Are there other processes that are happening? And so we will definitely keep looking into that. And then thirdly, the importance of scope. So not just for the position papers, but also for our project, we should make sure that it doesn't grow so large that it will become unmanageable. And so with that, I hope that 1 year from now, 365 days from today, when we meet, we will be able to assess how successful we have been on all of those 3 counts. So those are my finishing words, and I'm going to pass next to Ágnes.
Okay, thank you very much, Kubo. I very much appreciate the opportunity to be here and work with you. The great and interesting questions. So it's Kubo makes it quite difficult actually to say something meaningful after his good summary. I just want to assure our consortium colleagues and partners that they enjoy our full support, and we will do everything to make this project a success and come up with a practical and useful resource. Yeah.
Thank you, Ágnes.
Any final words from the panel, our wonderful panelists?
I will say one thing. I very much enjoyed the discussion and listening to colleagues from other government. I thought this national position is a good opportunity for internal discussion among different departments. Actually, international lawyers working for the State Department do not have much access to the information about the activities done by the other cyber security sides. So I think this is an opportunity for each government to deepen discussion, even among the intelligence departments. That would probably make your policy more consistent with international law. And I think side effect or byproduct is you can also talk about the general rules of international law with other departments through the topic of cyber activity. So that is kind of merit of publishing national positions, I think.
Thank you. John, Kerli, any final thoughts?
I would maybe just say once again that even though it's a challenge, then it's a really interesting and useful challenge, not only in terms that, this is something we have to do. No, after that, You are so much wiser. Also in terms of international law, not only lawyers, but also the technical policy people, everybody. I mean, it's spreading knowledge among us and building capacity at the same time. So this is worth doing it.
It's both a challenge and an opportunity. And on that, please join me in thanking our panelists for today.